So welcome to this little taster of the session that I'm going to be running for Child Talent, looking at whether children who offend should keep their anonymity. So this is a question that's been asked in the media very recently due to a recent case, and I think it's going to keep cropping up. So it's a very interesting question to look at. So this is what we often get. When you see children who've been convicted of crimes, you'll see that the reporting is vague. It doesn't identify the children, there's no photographs of the children. We get the kind of phrase I've got in the bottom, the boy who cannot be named for legal reasons. This is something that we will see very often in the media because of the way that children are protected. Now, why are children protected in law? So there's a number of reasons for this. I've picked out some of the main ones, really, why it's important to protect children. They are vulnerable just because they are children, and a child is identified as anyone under 18. And children are felt to have a lesser culpability than adults. That means that they are not so able to really understand what an adult might understand in terms of the consequences of their actions, what might happen if they do this, what it is, what might happen that might hurt somebody. They may be just much less aware of any of this stuff. And so I picked out a couple of the main things that are leading to this lesser culpability. The first one is something that we're really learning more and more about at the moment, and it's about brain development. And so children have a less developed brain. In fact, we're finding out that people's brain development continues well into their 20s. So if we're thinking about children under 18, then they really do have very underdeveloped brains, especially in the areas of the brain that deal with things like decision making and fight or flight responses or reactions. And those are the type of things that can get children into trouble. And they're really affected by development. But that also then leads us to question whether children are able to have what we identify in law as mens rea. That means a guilty mind, the will and the understanding to commit an offence that we would assume in an adult is not necessarily so assumable in the child, because it assumes certain legal understandings that they may not have. It assumes that they have an understanding and a planning ability, or lots of things in there that may be tricky. We also have, alongside the fact that this might be difficult for any child, especially at the younger ends, and we are talking of children from the age of 10 in England and Wales, because that's when children have criminal responsibility. But within those children who tend to get in trouble with the law, there is an over-representation, which means it's more marked than is in the normal population, of certain difficulties that might actually make that understanding, that culpability, even less than for what we might see as a standard child of any age. They're more likely to have speech and language communication difficulties, adverse childhood experiences, which we now call ACEs, which is a way of packaging up a number of experiences in childhood, and which suggests that they are less likely to have good outcomes, more likely to have experienced trauma. They're more likely to have a range of special educational needs and disorders, learning difference, and they are much more likely to have been or be in care, as in looked after by local authority rather than being in families. So there are a number of reasons why it's important to protect children and give children special protections. So in England and Wales, what protections do we have for children? Well, there are a number, and I've picked out maybe some of the most relevant for what we're looking at in our session. So children should have a separate system from that's designed for adults. And in England and Wales, we have the youth court system. I've put should, because as you'll see later on, it doesn't always apply. They must have an appropriate adult, though, somebody who is with them when they're being cautioned, when they are being questioned by police, so that they have somebody to advocate for them, to make sure that their rights aren't being lost in the process. Their identity is automatically kept anonymous. So nobody is able to report on or give any clues as to who they might be. In the youth courts that I just mentioned, there are automatic reporting restrictions. So papers are not allowed to report anything that could lead to the identification of the child, which includes photographs. It includes anything to do with their address. They normally just say their gender and their age, and that's it. They can't really do anything else. And there's some quite heavy penalties for journalistic agencies that don't keep to that, so they do tend to keep to that. No public are allowed in youth courts. They are closed, and children must be accompanied by a parent or a carer. They can't be appearing on their own. And there are also different sentencing guidelines for children. So they will be subject to a number of different types of sentence than is available for adults. And that's both community sentences, so things that they can get that adults can't get. So, for example, a child can be given something called a referral order, which is the first community order that a child might get from court. They can be given custody orders, that is prison, but they are certain types of custody order that are different for adults, and they'll be for a lesser period of time. And there is a different effect on criminal records. They do get a criminal record from being in court and having a court outcome, but it has slightly a lesser impact on them than it would do for an adult. So these are the concessions that are particularly relevant for what we're thinking about today. But there is a big but here. We've got this thing called Crown Court, and you've got a picture of one there. Children can be sent to Crown Court, which is an adult court, so no longer in a youth system. They can be sent to Crown Court, and that will always happen from a youth court, but for mainly two different reasons. First is that they've committed a serious offence, and the youth court is only able to give sentences up to a certain level of length if you're thinking custody, and they may think, well, it needs to have more than that, therefore they're going to go to the Crown Court. So a serious offence will be sent to Crown Court, and children who are co-accused with an adult, that will always be sent to Crown Court as well. That doesn't matter on the seriousness. So there is a system which does sidestep some of those protections that are there for children. But protections are assumed, certainly for the beginning part of this, and this is all through now the Section 45 of the Youth Justice and Criminal Evidence Act 1999, which is the section of the Act, Section 45, which deals with keeping children anonymous and all the things that must remain in place. There are some concessions that try to make the court a less imposing place, because it's very imposing. Court officials, judges, and those who are acting, the barristers, can remove wigs and gowns in an attempt to make it more formal. They will tend to use the first name of children, not their surname, which they would do for adults. So there's a number of things to try and soften it a little bit. But the judge can direct that anonymity be waived, as in that they won't keep their anonymity after they've been sentenced, after the court case has finished. And what we find is that when there's a lot of interest in a story, sort of media interest, the media will apply to the judge to have their reporting restrictions lifted. And so the judge will consider that and make a decision on whether they will lift those reporting restrictions. There is now an automatic expiration of anonymity when the child turns 18, but the judge can order lifelong anonymity. So it's not beyond getting around that if it's felt to be needed. And it may be that a child who has committed a very serious offence, and there's a lot of media flurry about it anyway, that child on release, their life may be in danger, and therefore they may need to have anonymity applied at that point. So it may be that it's not necessarily the best thing all round, really. taking away that anonymity leads to this kind of thing. The media portrayal of children who have committed very serious offences, this is not to say that these are not awful things, they really are, but it does lead to something of a witch hunt. It leads to the kind of language that you see in these paper reportings. The one on the left is to do with the killing of James Bulger in 1993. And so we can see the words evil, pure evil being used against the boy, or one of the boys, shall I say, as depicted by his photograph. His photograph is there. And on the right, we have the much more recent case of those teenagers who killed Brianna Ghey. Of course, they were identified, and this has given rise to more discussion of this issue. Should they have been identified? There are a number of arguments on both sides of that, but we have the use of this language like evil monsters. And both of those paper headlines really feed into an understanding of why people commit crime, really based back in the 19th century, of people being born evil, people not having the ability to be rehabilitated, really. And so it brings with it a number of assumptions that really in research have been debunked. But this hardens a public understanding which is really inaccurate and can cause harm. So why might we be arguing against this? And if you see on the right hand side, I've put just a screenshot of the paper that I wrote with some colleagues looking at this and why we felt that those two teenagers should have remained anonymous. So we need to go back to the reasons for their protection in the first place. The fact that the children who commit very serious offences, or even the children who commit very serious offences, are children with a reduced level of culpability, understanding, and all the rest of it that we've already said, and with those additional difficulties. But also, there are other things to think about, because the way the media then takes over tends to monsterize children and cause children to be bifurcated into either very innocent children or complete monsters who we need to as a society, kind of eradicate. And that is not a helpful way of manipulating public opinion. And it does have the effect of making public opinion more punitive. One of the issues with that is that politicians are very, very sensitive to public opinion, or what they think public opinion is, and the media can sometimes make that a little bit obscure and can give an impression of what public opinion is without that actually being that accurate. So it can actually affect what policy is put in place, what legislation is put in place, what things are not revisited. It can really change what happens and make things more difficult. Identifying them can lead to vigilantism, can lead them to have their safety risked. And you've only got to see some of the sort of social media posting about the killers of James Bulger and others, and obviously this recent case, to know that actually that would not be an empty threat, that would be something that somebody may well carry out. Talking about them in these kind of ways really reduces the likelihood of rehabilitation being possible, being effective, because it's very difficult for then anybody to see them as anything different. And actually what we want to happen is that the children who commit very serious offences as children go on to be productive, law-abiding and safe adults. And so we need to be able to see that as possible in order to put that into action, and that's almost made impossible by some of these new newspaper headlines. From the victim's family's point of view, or the victim's point of view, if it's not a murder, it forever links their loved one to those people who murdered them, because you would not get the newspaper reporting on one and not the other at the same time. And that's been expressed particularly by Brianna's father as being very difficult, doesn't want that, doesn't want those names to be with his daughter's name in the same breath, but now they always will be. And that wouldn't have happened had they not been named. And of course, when somebody's life is in danger, they will have to be given a new identity, which is an incredibly costly process to do. So it's going to be very costly to the public purse to have them publicly known, and therefore needing to have a new identity when they are eventually released, because of the risk that release would cause to them. I want to just look at a case example. And before you come to the session, it might be an idea to find out a little bit more about this case, because there's some very interesting aspects of it that I'm just going to touch on very, very briefly. We will look at it in a bit more detail. And so think about what you think. So Mary Bell was a girl who, when she was 11 in 1968, she, along with another child, killed horribly 2 small children. We're talking about one of age 2 and one of age 3. Very small children, not together, in separate incidents. Now, Mary is known to have had an absolutely horrific home life. Her mother didn't want her and tried to give her away, sold her into sexual abuse effectively, and really, really appalling upbringing. She was, for these actions, she wasn't convicted of murder, she was convicted of manslaughter. And I think that this is because back in 1968, England and Wales was a less punitive place for children. And I think we've changed probably since 1993 in the James Bulger case. But at that point, she was convicted of manslaughter, and she was sent to custody. And her identity was made known. That's why we know the name Mary Bell. And if you Google her, you'll see there's a lot written about her on all sides of the arguments, really. She was released 12 years later with a new identity. Now, that wasn't smooth going, because the media constantly tried to find out who she was, and they did find out, and she had to then be given a new identity. And so again, this adds to the cost of the process, which wouldn't have been needed had she not been identified. And part of the argument for her ongoing anonymity is because she does have a child. She has a child who was not taken away from her because she was not seen as being a risk to that child, and she's now a grandmother. And she applied for lifelong anonymity when she was potentially going to be unmasked at the age of on 18, when that natural kind of transition was passed, and she was granted lifelong anonymity. And as far as we know, there is no more offending. So she's on a life order, which means that her whereabouts and what she's doing has to be known by the authorities, but there is no more offending by her. So possibly the fact that she's been able to live more of a normal life, have children who she looked after and was able to bring up very successfully, demonstrating the faith that the system has had in her ability. So showing that rehabilitation has changed the outcomes for this girl, this lady, and has resulted no more offending. So put that into the mix of what you're thinking about as to whether it is in the public interests to give the identity of somebody after they've been convicted, given all the negative things that could have on their rehabilitation, the negativity that can have for the public, and think, what does the public actually gain by knowing a name that then almost inevitably has to be changed? And I would suggest that the public doesn't actually gain anything by that. So it's time to vote on what you think. So I've got one question up here, basically asking, having heard some of these arguments and some of this discussion, do you think that children who commit serious offences should keep their anonymity? It's a very simple yes, no, or perhaps not sure, which is fine. So what's your opinion? And it's anonymous, so nobody will know who you are, but it will be good to look at the results when we do the session. So with your mobile device, you can either scan the QR code that's been on the screen for a while, or you can go to vvox.app and it will ask you for an ID, and you put in then the numbers that are on the screen, 138 864 107. It will take you to this question, and all you have to do is vote for which answer you would like. And we will have a look at those results when we meet in the actual proper session, and I look forward to having this discussion. Come prepared to give an answer for what you think as well, and then we will really open up the floor to lots of different points of view. And in a sense, really, there's no right or wrong opinion, but there are opinions and there are thoughts. There is maybe evidence in certain areas and not in others. So have a read around, have a think about it, and come with a bit of an argument to be able to make during this session. And I look forward to seeing you there.